the preamble first?
I read the preamble first.
Okay. My name's Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble this morning. In compliance with notification requirements of Ohio's open meeting law under COVID-19 emergency declaration, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and the mobile version and activated by clicking the hand icon. Please wait for the chair or the facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. We have also received emails from those who have provided written comment on a particular matter. And would you like me to call the roll, Madam Chair? All right, so Mr. Donovan.
Here.
Ms. Barnes.
She's here.
Alana Faith is absent this morning. And Ms. Britt.
Yes.
Madam Chair, we have a quorum.
Lori.
We will now swear in our new chairwoman. Kelly, could you please raise your right hand and repeat after me? I, Kelly Britt,
I, Kelly Britt,
do solemnly swear
solemnly swear
that I will support the Constitution of the United States
that I will support the Constitution of the United States
and the Constitution of the State of Ohio
and the Constitution of the State of Ohio,
and the Charter of the City of Cleveland,
Charter of the City of Cleveland.
and that I will faithfully, honestly, and impartially
I will faithfully, honestly, and impartially
discharge my duties
discharge my duties
as chairperson of the Board of Zoning Appeals
as chairperson of the Board of Zoning Appeals
of the City of Cleveland
of the City of Cleveland
during my continuance in said office.
my continuance in said office.
Congratulations.
Thank you.
Yay.
Thanks, Maurice.
We do have one postponement this morning.
Okay, where's that for?
Calendar 21-95, and that is regarding 14526 Puritas Avenue. The attorney for that appellant has requested a postponement for 60 days, and that would put us at September 13th. He says he has heavy court schedule, and that would be the first availability for him in September.
Okay, well, I think that's Councilman Casey's case. So, Councilman, did you hear that?
Yes, I did.
Alrighty. Well, we'll see you on September 13th.
Without objection.
I was just about to say that. Thanks. So yes, is anyone opposed to this postponement? All right, moving.
You're breaking up, Kel.
Oh, is anyone opposed to this postponement?
No.
All righty. Okay, go ahead, Liz. We have Councilman Griffin is here, so we'll do his case first. I guess I'll read since Alana's out. I'll go ahead and read it.
And he actually has two cases, so.
Okay. We're at 2198 East 82nd Street.
Yes, the last two, and then 21102, the appeal for the food license.
Okay. All right. We'll start with 82nd Street since it's up. So he agreed. Danielle Whiteside, tenant, proposed to establish a residential facility for 6 to 8 occupants in a B1 two-family residential district. The owner appeals from relief from the strict application of the following sections of the Cleveland Codified Ordinances as listed in the agenda and in the public record. Tim?
All right, everyone for this case who wishes to testify, I'm going to read a statement. Your response I'm looking for is "I do" with your name. Again, anyone looking to testify on this case, do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do, Brian.
I do.
Anyone else? Anyone else for this case? Last call. Hearing none, we go to history.
We have, we have Sonia Shakir with her hand raised.
Okay, Sonia, are you here to testify?
Yes.
I need an "I do" with your name.
Yes, I do. Sonia Shakir, resident.
Okay. Anyone else out there? Last call? Okay, hearing none this time around, let's go to history.
Thank you, Mr. Donovan. There's been no change in the zoning since 1929. In the Building and Housing Records Administration, I found that in 1945, there was a permit issued to keep 25 chickens in the rear half of a garage on the property. In 1962, a permit was issued to enclose the front porch of a single family. There are no variances on file, and in the more recent history, we found that in 2006, a permit was issued to apply a vinyl siding to the property. And in 2016, a certificate of occupancy was found stating that the authorized use of the structure is two-family. And that's all that I have.
All right, thanks, Liz. We'll move to the legal standard.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance not be contrary to the purpose and intent of the zoning code.
All right, thank you, Ms. Wagner. Who's going to be the spokesperson for this case?
I am Danielle Whiteside.
Okay, Danielle, go ahead, present your case.
Thank you so much. Good morning. I'm Danielle Whiteside. This is my part owner, Tracy Lumpkin. And I'm just going to read briefly because I was trying to make sure that I'm prepared and I didn't miss anything. This home on 2198 East 82nd that we are looking to utilize as a group home, there's a greater need in the community for group homes that offer structure as well as safe environments while assisting residents transition from one aspect of their life to another, whatever that may be. I currently work in the mental health and substance abuse disorder field, and I see how firsthand the impact that this illness has on individuals. Also, the pandemic created barriers for people with finances, housings, loved ones, mentally, physically, emotionally. And I watched the decline of the mental health patients decline after dealing with the pandemic. It left a lot of people feeling lost and hopeless. As an African-American myself, it is my hope and my passion to be able to help others in the community to improve their quality of life by providing stability and guidance. Our goal, simply a pathway to purpose, is to assist as many people as we can, but however, always keeping safety measures first. After speaking from a representative from the street club, with my peers, my mentors, and other people that are in this type of field, we have revisited the need for an in-house staff person to reside in that home daily, to be like a guardian over the residents. We understand that we must be mindful of the safety of the residents on that street as well as in the community and the children in that community. Our group home will not house any sex offenders, pedophiles, or anyone with severe violent history. We're looking to only do male clients between the ages 25 and up. 25 and up. We are requesting at this time to house 6 residents and one in-house staff person. We are hoping to be an asset in the community, and we welcome any suggestions to assist us with this project in order for us to be compliant with state regulations. Pathway to Purpose Group Home is simply to open up doors for people that are in need with mental illness and or substance abuse. Thank you.
You're muted, Kelly, I think.
Oh, yeah, I just
Or-
saw that. Sorry. Yeah. Okay. So you say you will have a staff person. Will this staff person, what kind of hours will this staff person be at your facility?
Well, we're looking at two ways to revisit it because it is a need. So if we're looking for staff, they're going to do 2 12-hour shifts. So someone will be there, plus me and my business partner will be there daily, at least for the first couple months until we can get the staff person up and running, identify any needs and make sure that it's running properly. The other route would be just a actual live-in person. This home, is my understanding, that was a 2-family, but the property manager and the owner converted it into 1. So it's a single family now. So those upper bedrooms, they're huge. That's why we were proposing where we were looking to do 6 to 8 people in the home period. But now we're thinking to revisit that, and we can use those upper rooms. One would be a multi-purpose room, which would be for case management, meetings, group, things of that nature. And the other bedroom would be identified for the in-house staff person to live there on a regular basis.
Okay, Liz, do we get any letters or anything from the community?
Yes, Madam Chair, we did receive just this morning 17 letters of opposition. These are form letters, and they are signed by residents of East 82nd Street, East 83rd Street, 82nd, and so on. If you'd like me to read that form letter, I'd be glad to.
Yeah, read that for the record, and then we'll just stipulate the amount of people you said signed it.
So this was directed to Councilman Griffin. The author states that I'm opposed to the above address being designated as a residential facility in my area for many reasons. There are too many designated and undesignated facilities on this block, and homeowners are highly concerned that the neighborhood will turn from a close-knit, family-oriented community to a commercial district. Danielle Whiteside has stated that the residents are highly functioning mental patients. Below are highlights of our many concerns of the mental state and past history of the supposed highly functioning residents. Number 1, history of substance abuse. Number 2, history of criminal justice. Number 3, homelessness equals breaking and entering. Number 4, global assessment and functioning. We appreciate your help with this process. Thank you, a concerned neighbor. And all of the 17 letters have the exact same language. As I stated, these are form letters.
Thanks, Ms. Kukla. Sonia, I believe, was a resident that was sworn in. Would you like to make a statement?
Good morning, everyone. I live directly across the street at 2205, and I feel the same way as the other 17 residents, where I'm a single mother over there with 2 teenage daughters, so I feel the same exact way. The home is now unkept. The grass is overgrown. I have not seen, the owner. They did come over there and run the lawnmower over the grass, maybe because they was preparing for today. Just the last couple of residents that was there that had a lot of issues in the home. I only been on the street myself. I'm new to the community as well as of 3 years, but just I'm just concerned. It is, the area is kind of overpopulated with those other group homes. I'm not sure. This document, we have one that is kind of well kept on the street that I don't have an issue with, but just in the area, and those concerns that brought up by the other 17 residents, I'm in agreement with it.
Thank you. Board, any questions?
Madam Chair, I did get a video from from the applicants. Do you want me to show that? It's of the inside of the house.
Sure, why not?
Okay, I'll cue that up.
He's queuing that up. Board, any questions?
Has there been any official public interaction, a community meeting regarding this proposal?
We have not, me and Ms. Lumpkin have not been aware of any. We'll be more than happy to attend if there's an invite proposed.
You know, it's often that when we have a case come to us without any community interaction, that any reaction we do get is against the proposal because there's too many unanswered questions. What's the hours of operation? How do you get your clients? Blah, 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 blah.
Mm-hmm.
So we usually end up putting a halt to the decision making to allow for that due process to happen so that at least whatever judgment we make is done so in the light of whatever facts there are and questions answered, etc.
Okay.
Councilman, this might be a time if you want to chime in.
Sure. You know, I'll answer a couple of those questions that Mr. Donovan had, as well as a couple of the concerns from the residents, and just kind of let you know how my thoughts on this. So I'm opposed. I oppose, you know, based on a couple of the things that have already been said. This area is really oversaturated with I think legally operating as well as illegally operating reentry houses and group homes and all kinds of other of these kind of facilities. We've had a lot of challenges, especially in this part of Fairfax, where because the houses are so big, people are putting these homes in. And in a lot of cases, I'm really working closely with building and housing to really try to regulate them and really try to identify the ones that are illegally operating. I do believe Ms. Whiteside, who reached out to me on Friday, you know, is a good person who really, you know, is approaching this in a professional manner. The only interaction that I have been made aware of is between Ms. Whiteside and a couple of the residents sharing emails back and forth to each other. So the answer to your question, Mr. Donovan, I don't believe that there has been a public meeting where all of these stakeholders have been able to interact with each other. It has been mostly via emails. I share the concerns that Ms. Shakur and others share, that we have an oversaturation in this area of group homes. And we have families that really have bought their. Ms. Shakur, for example, just bought her home, brand new homeowner, very recent. So we really have some concerns regarding this. We are not a community that's a NIMBY community. We have invited our share of these group homes and really been supportive over the years. However, we should not be the only community in this area that's just getting inundated with these kind of groups homes, especially in this area because of the style of homes. So I am opposing this, and as well as the residents who I serve who live on this street have voiced their vociferous opposition to this. And even though I believe there has been some adjustments made from Ms. Whiteside, I still have to oppose because you know, I may be able to reconsider at a later date, but at this time, I just have to oppose based on the outcry from the community, as well as my concerns about oversaturation of these type of group homes in the area. And really, other than some of the brief updates that I've gotten now, I really don't understand the operation and some of the things that Mr. Donovan said. How would they get their clients? You know, all of those different kind of questions that we actually need to answer. So at this time, Madam Chair, I oppose, and thank you and the board for your consideration.
Thank you, Councilman. So Ms. Whiteside, do you understand that everyone's opposition to what you're trying to do here?
Yes, I do. I heard it, and I respectfully, I hear. May I ask a question at this time? Would that be okay? I understand the concerns. I didn't realize, so thank you for the education piece, that there were so many in that community park area. but I also would like to have the opportunity to not be labeled from behind them. Pathway to Purpose, I can't speak for the other group homes. I work for an agency. I've been in this field for 7 years. These aren't people that we're just going to say, hey, grab so-and-so off the street. You know, we're working with agencies, wraparound services. So, and this place is going to be structured. Again, I do respect and I understand the concerns as a homeowner myself that just moved into a neighborhood and not really knowing, you know, who's who. But I also, after speaking with the owner, and no disrespect to the people that lived there prior, because I don't know, there was a lot of people in there with a lot of different backgrounds and a lot of things going on. So I guess my question is, even if we're denied today, respectfully understood, the owner and the property manager, do we really know who's going to be in the home? It's 8 bedrooms there. So we could have anyone from sex offenders to people out of jail to just people that don't care about the community. I was hoping that at least because we are trying, we would like to partner with you all. And this isn't the only thing that we're trying to do. We want to do other things in the community. We were looking for buildings, rec centers for the kids. It's things, there's other things that we're trying to do. So I guess I'm disappointed, but we understand. We just was hoping to have the opportunity to open up the doors in a professional, structured environment for people in need.
Okay, just to let you know that if we do not approve your variance today, that goes with the house. So no one can come in later and put in a group home unless they can prove a different type of situation. So, Councilman, do you think that Ms. Whiteside talking to the community will change their mind at all? And if not, Ms. Whiteside, you might want to just think about withdrawing your case today, so there's not any prejudice against the house today. And then maybe
Okay.
you can maybe you can regroup and talk to the councilman and see, like, if this is something that the community really doesn't want, maybe you can come up with something else there. But I don't know, Councilman, how do you feel about that? Well, I think he's muted. You're muted.
My apologies. Ms. Britt, you're exactly right. I don't think as much that I can say to change the community's mind on this. I do believe, be honest with you, that Ms. Whiteside is a professional, and she is the type of operator who I think at some point in time, I would love to work with the community to try to put a good establishment in place. However, in light of the recent oversaturation of these type of facilities in this footprint, and the community's vociferous opposition to it, I don't think it's much I can say to overturn that. So I would also recommend that she probably withdraw and then maybe see how we can engage and maybe look at a different option and whatever else we can look at in the future with this close-knit community, because this is a close-knit community.
Madam Chair?
Yeah, I was gonna say, Liz, is that you?
Yes, that's me.
Okay.
I do have one piece of information that that I should have announced at the beginning. This is not the owner of the property. High Grade Properties is the owner, and they have submitted a letter of authorization for her to act on their behalf.
Okay, thank you. Board, any questions or input on this? What would you like to do?
I think the ball's in the appellant's court. Would she want to withdraw this case at this time or not?
I want to make sure that I'm understanding if we withdraw, then it's just over. What other options at this point would we have?
If you withdraw, that means that you can regroup and come up maybe with something else, or try to convince the community that it's a good idea for your project to go there. If we rule on it and not approve your variances today, that means it's over. So you can make the choice of to withdraw now and figure out, or you can have us do a vote, and if we disapprove it, then that's it. It goes with the house. So then that's it. Nothing else can happen.
Madam Chair, we have Lori Wagner with her hand raised.
Oh, Lori, go ahead.
I would just like to advise the appellant, since nobody else has brought this up, that if you have 5 or fewer people in your group home, it is something that's allowed, although you have to meet a requirement of being at least 1,000 feet away. And if you're not, then you'd have to come back for a variance. But it would be, this variance here is a use variance, which means basically the legal standard is there's nothing else you can do with your property. 5 people or fewer is considered a use that's more compatible with a single family homes, 2-family homes, residential neighborhood, and you would be able to do that if there's no other facilities within 1,000 feet, or if there are facilities within 1,000 feet, if you came back to the board and asked for an area variance. Just to put that on the record.
That's good.
And Madam Chair, to your point, there are facilities within 1,000 feet. So that's one of the concerns that was brought up after we looked at that. And as Ms. Shakur brought up, that's a facility that is pretty much legally run, that the community has supported. And that's one of the reasons why we've actually have this opposition.
Thank you,
And
Councilman.
sorry, Madam Chair, this is Liz again. The one more thing, the withdrawal today, and this is just a detail that the appellant should know. A withdrawal today would mean that she would have to reapply and receive a new calendar number. So the withdrawal would not be a postponement. It would be a full withdrawal of the case and a reapplication in the future.
And Ms. Whiteside, you understand?
Yes, thank you so much.
What would you like to do?
Actually, we're just gonna go with the vote this morning, if that's okay.
Okay. Board, she would like to go with a vote, so can I get a motion?
Madam Chair, based on the testimony, I would move that we would deny the variance request.
Second.
All the roll, Ms. Cooper.
Ms. Barnes,
Yes.
Mr. Donovan,
Yes,
Ms. Britt.
Yes.
Calendar 21-97 is denied. It'll be ratified next week and we will send you a letter.
All right, thank you. Good luck, Ms. Whiteside.
Thank you so much for your time, everyone. Have a good day.
is Alana on the call now?
I
Yes,
am
Alana
present.
has joined us.
I am present now.
Great.
Welcome, Alana. Would you like to read now?
Yes, I can go ahead and do that. Do we have Councilman Casey? We want to do that next?
No, his got postponed
No, we have
actually.
another.
So we're gonna do what's on the screen now, the assessments and license decision.
Okay.
Is,
Councilman Polensik is here.
Okay, is Blaine still here? Councilman Griffin?
Yes, I am. I am still on, and I believe I have
Okay.
the second one. Yeah.
Right, and then we'll do Councilman Polensik.
Okay, Alana.
So the license decision is our next case. And that is calendar number 21, excuse me, 21-102. Oh, sorry. Excuse me. Appealing the Commissioner of Assessments and Licenses decision, Emmanuel Sambusin, I'm so sorry, Sambunaris, otherwise known as John's Hot Dogs, owner, appeals under the authority of Section 76-6B of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the decision of the Commissioner of Assessments and License to deny application RLUMF 21-00014 dated June 2nd, 2021 regarding denial of vending locations in Ward 6, filed June 8th, 2021.
Thank you, Ms. Faith. Go ahead, Mr. Donovan.
Everyone, for this case, I'm asking you to raise your right hand. I'm going to read a statement. I'm looking for a response that says I do, and then adds your name to it. Here we go. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do, Blaine.
I do, Commissioner Stevens. I do, Emmanuel Tabunyeras.
Anyone else? Appearing not, I don't think we have history, so I go to the legal standard.
Thank you. Madam Chair, members of the board, appellant is appealing an administrative decision. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you, Ms. Wagner. So who's here for this case that would like to speak?
I believe we have Emmanuel.
Emmanuel?
Yes.
Okay, go ahead.
Hello, everyone. I'm Emmanuel Tabunyeras. I'm the owner of the Dog Father, John's Hot Dogs. We've been operating in the Ward 6 for me and my family and I for over 40 years with no complaints, no history of complaints. And, you know, I'm a civil hot dog vendor. We every year we do the same application. We apply. We've always gotten our locations, and this year was the first year that we were ever denied locations for the ones that we've been applying for every single year. All I'm asking, I mean, this is my livelihood. This is what feeds my kids, my family. If I can just, I'm not asking for any more spots. I was told that there were more locations added, and that was a reason for a denial. I personally, myself, only apply for the locations that I've been working for the past 40 some years, me and my family. Basically, that's all I have. Yeah, and I was told there was like over 30 spots applied for, and that was not me to get those locations.
Madam Chair, just wanted to
Oh.
point out, I tried to map the locations that he had on his letter. I'm
Yeah, I
not sure
see.
that I got them all right because some of them were Clinic Drive, and I'm not sure where Clinic Drive is. It wasn't
Yeah,
on the map, so.
Clinic Drive is the walkway in between the Cryo Building and the Glickman Tower, and
Okay.
it's in like that. Like if you look south of Euclid, it's those two pathways in between 96 and 100.
Oh, right here then.
Yes, that one, and we're in.
So I might have gotten them. I may have gotten them close.
You're close, but it's a little bit further south.
Okay. I just wanted to give the committee an idea of what we're talking about here.
Okay, thank you, Emmanuel. Commissioner Stevens is here. Would you like to present your side, please?
Good morning, board. Yeah, virtually pursuant to the Public Health Code 241, Section 241.36, Councilman Griffin has denied the location for, I should say, 6 locations. And I believe that there were a number of questions that he had in regards to the operations, and I will turn it over to the councilman now.
Thank you. Madam Chair?
Yeah.
Okay, thank you. So I'm going to rescind my objection, but I do want this board to understand that this is something that we really have to look at with the Division of License and Assessments, as well as our Cleveland City Council. I've had a lot of conversations with a lot of my colleagues. After talking with Mr. Samboris, I am going to rescind my objection. I support him putting these locations in place. Just to give you some scope of what has happened, because this may just come before you again. There was several vendors that have put in almost in excess of 60 requests inundating the University Circle, Cleveland Clinic area. And I've never gotten this amount of requests. And in a lot of cases, when I asked a couple of the vendors, well, how many trucks do you have? They said, well, we only have 3, but they were requesting like in some cases 60 and 70 locations. So in essence, what they were doing was trying to block the competition by trying to get approval for several locations while their trucks were only able to operate in any. In addition to that, there's a fairness issue that we do want to make sure that we support competition. That even though I understand Mr. Samboris has been doing this for 40 years and I support him and his family's business, I do also think that government always has to provide fairness and make sure that we allow a competitive process whenever these corners are coming in place. But after talking with Mr. Samboris and really understanding his business model and plan, and this map that Mr. Rulings put in place is really helpful. And, you know, he's never had to deal with the scrutiny that I've given. So I don't know why, but probably because of being inundated with so many requests. You know, now he kind of understands that he needs to at least touch base, understand the model. And that's what I'm going to ask all the vendors to do now, because this year was the craziest year. I mean, I've got excess of about 60 to 70 or so applications for these corners. And it was just an overwhelming process. So I started denying until I can understand the business model more. So I rescind my objection and support Mr. Samboris at this time.
Thank you, Councilman. Ms. Wagner, so what does that mean for this case now that the appeal doesn't really need to be appealed anymore?
I
Well,
asked Mr. Stevens that question.
Well, legally, it still was a denial and there was an appeal. It seems like the basis of the denial was that the councilman objected. But as Mr. Donovan said, perhaps Mr. Stevens could speak to that and indicate whether Assessments and Licenses still objects to this with the councilman's support.
With a letter from the councilperson's office saying that the locations are approved, we will issue the permits.
And Madam Chair, I will draft that and get that to them and CCU as soon as possible. But I do have a question for clarification for I believe Ms. Kukla. It's also with the appeals process is if the appeal, if I'm understanding, was, and I know I apologize, I don't have the language in front of me, but it's capricious and other things. But I thought one of the things they said in the appeal process is that if there was not a full understanding or the scope of the evidence or whatever that means. So that still wouldn't apply. My question to you.
So, Madam Chair, to his question, if I understand this correctly, I am wondering if Councilman Griffin is asking if the board should still uphold the decision because it wasn't arbitrary or capricious when they made that decision, as it was based upon the information that they had at that time, the preponderance of substantial, reliable, probative evidence. So I'm not sure if that's what the councilman means. It sounds as though the councilman did not have enough information when he made his decision to not sign off on the license.
Could the lawyer speak to this now? When you have this appeal hearing, you have a right to bring in new evidence. And in fact, new evidence was brought in here today, which is that the councilman having more information does not support this. The proper, I think, the proper thing to do would be to rule on the appeal. Unless the appellant wants to withdraw altogether, but otherwise the board could rule on the appeal and would be doing that based on whether it's now supported by the preponderance of substantial, reliable, probative evidence.
Thank you, Ms. Wagner. Board, what would you like to do?
I think that the language that speaks to the unreasonable or unsupported by the preponderance of substantial, reliable, and probative evidence is the key point here. And I would say that given the interaction and the testimony here, especially by the councilman explaining the predicament he was put in as kind of a veto power and his rescinding that veto in this particular case, I would have to say that this is a circumstance where I would deny them the request by the city as it being arbitrary capricious and move forward based on the new evidence provided by the councilman and Mr. Stevens himself.
Madam Chair, if I may jump in.
Sure.
To Attorney Wagner, are there three options that the board can make, decisions that the board can make today? They could approve the appeal, they could deny the appeal. Isn't there an option to dismiss this appeal as well?
That is an option if the appellant feels comfortable dismissing it based on the representation on the record that assessments and licenses will be granting the permits, then that is an option.
So that would be the appellant saying that they want to dismiss it, or?
Right. I don't know, you have a record here now and you have a case in front of you, and I think it would be better if the board made a decision on it, just so there isn't any confusion in the future. And once again, that decision can be based on the evidence that's in front of the board at this point. Well, is the denial still supported by the preponderance of substantial, reliable, and probative evidence?
Madam Chair, I'll float a motion out there that we would vote to dismiss the case given the new evidence provided through the councilman and Mr. Stevens that will allow the permit to be executed by the city of Cleveland and the appellant.
Get a second?
I'll second that.
Thank you. Call the roll, Ms. Kukla.
Ms. Barnes,
Yes.
Ms. Faith,
Yes.
Mr. Donovan,
Yes.
Ms. Britt.
Yes.
Calendar 21-102 is dismissed, and we will send you a letter.
Thank you, Madam Chair and Board.
Thank you.
Thank you.
Thank you. I believe Councilman Polensik said he was here.
Yes, I'm here. I'm here.
Okay, we can do that case next.
All right. Moving on to calendar number 21-093 at 16115 Waterloo Road. The McPhillips Way owner proposes to erect an 80 feet tall automatic changeable copy digital pole sign in a C2 local retail business zoning district. The owner appeals for relief from the strict application of the following sections of the Cleveland Codified Ordinances as stated in the agenda and the public record.
Thank you, Faith. Mr. Donovan?
Will everyone for this case raise your right hand? I'm going to read a statement. I'm looking for a response of I do with your name. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do. Mike Polensik. I do.
Thank you. Anyone else? Appellant, are you out there? Is there no
I think you're
appellants?
muted. Yeah, they're here. They're just muted.
Okay.
I do, yes.
Your
Yeah.
name?
Yeah, I
Oh,
do.
there we go.
Tom McPhillips and Sean.
Okay.
Um,
Anyone else? Hearing none, we go to history.
Thank you, Mr. Donovan. This property was originally zoned general retail in 1929 until 1996, when it was rezoned to the present local retail business. There are no variances on file technically, but in calendar 97-230, the same owner applied to erect an 80-foot high telecommunications tower, and that case was ultimately withdrawn. And then also regarding the building on the site, we found that in 1914, a permit was issued to erect a two-story store with a dwelling. And then in 1961, a permit was issued to demolish that store and residential building. And that's all that I have, Mr. Chairman. Oh, sorry, Madam Chairman.
I was gonna say, now become Mr. Brett. That's my grandfather. Okay, moving on to the legal standard.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance and area variances from the sign regulations of the zoning code. To obtain use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance. Will deprive the appellant of substantial property rights, and the granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and the granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you, Ms. Wagner. Who's going to be speaking for the appellant today?
We can speak for ourselves.
Okay.
Tom,
What was your name? What was your name again?
Tom and Sean McPhillips.
Tom and Sean. Okay. Go ahead.
Yeah, before the wall was built, we actually had a sign that was visible from the highway. And recently, well, after it was built like so many years ago, it did affect our business. Like that was a huge natural like advertisement being able to be seen. And we were saving up to raise the sign and to make it visible for the property. So we feel like this is help reverse the hardship we incurred from the sign. And actually some other districts, Euclid, they actually took down their wall for one of their car dealerships, the Sims. So this is we're not asking to remove the wall. We know it helps the neighbors with some sound reduction. We're just helping to gain access to that natural advertising we had when we initially got the property. We understand that there are some variances needed, but I think what it boils down to is the effect on the community. And I've talked with all of our adjacent property owners, including Jerry Schmidt, the sculptor, Cindy Barber from the Beachland Ballroom, Al Harrison, our adjacent property neighbor, Colin Barth, who owns residential property around us, Marcus Sanders, the photographer next door, and they've all been aware and of the effect of what it could do and help us, and they're very sympathetic, as is Jessica, who's associated with the Praxis workshop, and others I have here in my folder, including Alan Davis, another adjacent property owner to us. So we've made many attempts to make this sign incredibly efficient at what we want to help us help restore our access to the highway. But also the sign, you can see from this diagram, is tilted towards the highway to further enhance the visibility, but also decrease the illumination effect from the surrounding properties, which, mind you, it's already it'll also dim at night to like the level of an iPhone too. So we believe this sign is well designed to accommodate our needs, but also fit well into our community. And we've explained and educated everyone about the specifics. And as you see, it's already very close to the highway. It's only if you were to map that, make a direct line to it, there's not too many properties that intersect. There's just Waterloo Road and maybe the photographer shop I mentioned, the Marcus guy, but he's significantly farther. He's past East 161st Street. So this will help us with our initial problem of losing access to highway advertising. And in addition, we're doing it the right way. We're getting our community involved, the neighbors, and they are on board with this.
Well, thank you, Mr. Phillips. Maurice, I neglected to ask you to summarize these variances And just kind of, while you're doing that, if you're going to be the spokesperson for city planning today, or I don't know, if there's a planner here for that area.
Yes, I will be. I want to see. Can you see this? I have a different presentation up.
Yes.
Okay, I just wanted to go through. Well, I can summarize, and I wanted to go through the same presentation that Shannon Leonard made at the City Planning Commission, and I would like to point out that this did go to the local design review committee. It was denied there. They then appealed that and took that to the City Planning Commission, to the full Planning Commission, and it was also denied there. These are significant variances. As you can see from this, the first graphic, the applicant is proposing 219 square feet. That's 169-foot variance from what is actually permitted by the code. And here we have the freestanding signs are only allowed to be 12 feet in height in local retail districts, which is what this district is, 25-foot height in all other districts. Again, the applicant is proposing 80 feet above grade, 69 feet tall. Variance is required. I think this graphic here kind of really sums up what's going on. Freestanding signs are only permitted to be 12 feet in height, as I already stated. And again, this is a 69-foot tall variance. Just some more views of what this sign is actually going to look like when you put it in scale. I believe they have removed the automatic changeable copy sign portion, so I'm not going to go into that. This is the motion that was made initially at the local design review committee. They initially tried to approve it, but that did not pass, and then it was denied. And in the initial motion, they talked about the fact that there is the Rick Case Hyundai sign that's not far, but the Rick Case Hyundai sign is only is not as tall, and it's within 50 feet of a residential district as it fronts the property. So they needed no variances for this sign. I'm sorry, it's only 48 feet tall. And it is legally established freeway interchange sign because it is right on the freeway ramp. So I just want to go over the variances that are required. So you'll need a 169 square foot variance for the square footage of the sign. 69-foot tall variance is required for the height of the sign. And again, the automatic changeable copy has been deleted from the application, so we don't need to go into that. And that's what was presented at the Planning Commission. We do not support this sign. We think it sets a dangerous precedent, although we do look at all cases individually. I think that approving this sign would set a dangerous precedent.
Thank you, Maurice. Board, any questions so far?
Yeah. Can I say something here?
Sure. Hold on one sec. I just want to see if my board has any questions, then I'll go right back to you.
I have no questions at this time. Although it's difficult even on a sign of this size to read what your business is, gentlemen. So that's my only comment at this point.
Okay, Mr. McPhillips, go ahead.
Yeah, I'm the old man here. I used to work down at CMHA Estates. They were kind of dangerous, but we did a lot of work down there. So when we originally put this sign up, we got away from working on some of those places. And when we had this sign up, after we took it down, we lost about 80% of our residential business. We do have some commercial accounts, but all we do now is commercial service. We do some residential service too, but we no longer have a sheet metal shop. I had to let 4 people go. There's a lot of installs going on that we're not getting because of this sign. And I could be doing install work, but now we're just doing service work because of that. I've been here over 40 years. And so I think it would help everyone, and I could employ more people if this sign were up. It was valuable to our company.
Thank you. Councilman Polensek, would you like to speak now?
Yes, can you hear me?
Yes.
Okay. I've talked to the McPhillips family. They've been longtime business operator in the community. I've talked to some of the adjacent property owners as well. And looking at the reality of what the noise wall did to their advertising aspect of their business, I support the granting of the variance. I don't believe it will set a precedent in this area. This is the only business that has approached me with installing a sign. There are billboards. There are two billboards, one almost diagonally across the street, which is right next to the noise wall, and virtually touches it. And then there's one farther up the street that is westbound, which is, I believe, even taller. But there are trees that have grown up around it, massive trees, so you don't even see it, but it's there. There's a sign, an old billboard that is there, just off of 152nd Street at Daniel. So I don't believe this will set a precedent in the community. They're at the very end of the Waterloo Arts and Entertainment District. And if you look at the aerial, you can see that there. They are right there at the very end of, there's no other businesses to the east of them. They're at the very end. And so, in a way that the sign is angled toward the shoreway, will not adversely affect the residential neighborhood. So this is another effort as we're trying to support businesses in our neighborhood. We tried to work with ODOT. ODOT would not permit any additional additions to the billboards that are there, or signage on the billboard along the bottom or the top, because of some requirements, some state requirements. So this clearly is their only option to promote their business, is to have a taller sign on their property. So I'm here to support it.
Madam Chair, we have Lori Wagner with her hand raised.
Just for clarification of the record, was there testimony that the request for automatically changeable copy sign has been withdrawn? Is that correct?
I not well, by automatic changing. I think there's an LCD below it, but it's not automatic unless we manually change it. So if that's what you're referring to, that's not automatic. It's something we do manually.
Well, if that part of the request has been denied, I just wanted to, or has been withdrawn, I just wanted to make the point that the legal standard would change. There would not be a use variance required, but there would still be the pretty substantial area variances. However, those are different legal standards, so I wanted to advise the board. If number 4 has been withdrawn, then these are all area variances.
That would be my mistake. If you're saying that it is a changeable copy, you can change it from a remote location and not have to go up to the top?
Correct. It's
then it's still the changeable copy sign. I believe. Mr. Riccardi, you probably would.
That is correct.
That was my mistake. Sorry.
Okay, thank you. Board?
So does that mean there'll be various messages that'll be incorporated into the future of this sign?
We would change the message probably seasonally. Like if it's the AC season, we'd probably put a picture of an air conditioner, and if it's the heating season, it makes sense to put a picture of a furnace. But I mean, it's generally a message promoting services that we're comfortable doing.
And it's limited to messages with your company, so no other outside vendors could access that billboard?
Correct.
For lack of a better term?
Correct, yes.
Is there a height at which a compromise could be reached, so you don't go 80 feet in the air, you go?
Well, the height was determined from like the height of the wall and to have a visual of the highway. So unless we could own the property, like literally past that, if you look at the aerial past the sidewalk, unless we can get like access to this land, which, you know, HVAC, our competitor has that billboard almost like exclusively now, and we would keep it build closer to here, which I don't know. I think that's city property, so we'd have to buy it, I guess, from you guys. But Right now, the best way to get the highway is to build that sign higher, and the 70 feet is the bottom of the sign, and that's to have the lane on the far right visible for it. And if you lower it, then instead of having that lane visible, you start reducing the lane for each like 5 to 10 feet. So we could lower it, but it becomes less visible from the highway, which, I mean, trust me, I want it to be as low as possible because that it just makes the whole construction easier. So I didn't choose this because I want a really high sign. This is just the sign that works for this function.
Any other questions, board?
Madam Chair, could I ask a question?
Sure.
To the council person, do we remember, and maybe he stated this and I missed it, do you remember when the sound wall was put up?
Oh boy, that's gonna be a tough call. I'd say at least, I'd say 15 years ago, 20 years. I mean, I'd say around 15 years ago, I would think.
And that's what I heard too. That's what I've been told. 15 years.
Yeah.
Thank you.
Okay.
Ms. Wagner? And
yeah.
looks like Ms. Wagner and Mr. Riccardi have their hands raised. I'm not sure if one is from before. Sorry to interrupt.
Oh yeah,
Mr.
no,
Chairman.
that's fine. Go ahead, Ms. Wagner.
No, that was raised from before. I just unraised
Oh,
it.
maybe it's
Mr.
Mr.
Riccardi?
Riccardi.
I just think it should be made clear that it's also an appeal from the denial of the City Planning Commission or acting through the Design Review Committee. So as long as it's clear that that's on the table too. Thank you.
Thank you, Mr. Riccardi. Board, any other questions? If not, I'll entertain a motion.
Just one question based on Mr. Riccardi's contribution there. Does that mean that if we approve this, this could still be challenged as going against a ruling that was arbitrary, capricious, etc.? Anybody hear me?
Yeah, we heard you. I don't know. Was that was geared toward Mr. Riccardi?
Yeah.
Mr. Riccardi?
I just think that it should be incorporated in this appeal. Sometimes it's cited in the notice of nonconformance, and sometimes it isn't, but it's needed in this case since it was denied by the Design Review District. I just need to know, because if this variance is granted, I need to know whether to go ahead and grant the permit or in effect, is the city planning design review decision also overruled with this in this case? So that's what I just wanted to bring to the attention.
Ms. Wagner, it's not written up that way though. Does that cause a conflict of some sort?
It does cause a problem. It wasn't written up for that. I don't understand the background of this enough. I don't understand the statement about if in fact they're not automatically changeable copy, then there's nothing to appeal from Planning Commission. But it should be written up properly, and it was not written up that way. And which the appellant didn't choose to appeal that particular point.
The Planning Commission denial is important in this case, not just because of the changeable copy, but because it is in the design review district. And I think the reason that sometimes it's left off is that this board always defers and says we can't overrule the City Planning Commission, and so I mean, sometimes it's included that the planning commission approval is required and sometimes it isn't.
Well, of course, the board can overrule the city planning commission. That's what you're saying, that that's an issue before them. However, it wasn't advertised that way. I think it's up to the appellant at this point, if they understand what the issues are and want to go forward with this or want to.
Well, I do remember the meeting with the city planning commission, and at the end of the meeting, they felt like it wasn't their responsibility to approve it, and they wanted us to bring it to you to appeal for the final decision-making process. So I felt like they wanted your input in making the final call. That was my understanding. So yeah, I understand they made the decision, but they also wanted, they were afraid to approve it without getting your input on it too. So that's all right.
Madam Chairperson, if I may, that was my understanding as well. That's why they referred the appellant to the Board of Zoning Appeals for the final say on this matter.
Okay,
However,
I'm
Madam Chair,
understanding that.
as I displayed from the motion form, it was disapproved by the Planning Commission. The application was formally disapproved by the Plan Commission.
Yes, and by design review. So
and by design review.
And it seems to me that makes this an appeals case and not an actual normal just variance case. So yeah, I guess as Lori said, I guess it's on the appellant to what they want to do, or do we need to re-advertise this and come back later? Ms. Wagner.
I would just, yeah, I would just say that there are still variances, even if the board overturns the planning commission decision. I don't know. I don't know what the standards they were using there. I just know what was provided to us by Building and Housing, and it states the Board of Zoning Appeals has to grant variances for automatically changeable copy signs. And one of the conditions there is that it has to be approved by Planning Commission. I think, I don't know, we don't have any neighbors here. There's nobody that's prejudiced. I think if the appellant wants to move forward, the board can rule on all those issues, but it certainly would have been preferable to have the case written up in the appropriate manner.
Madam Chair, to that note, what we have done in the past is had the appellant make a separate appeal with the proper appeal statement and, you know, a response to the legal standards. So, you know, we have done it in the past as a separate appeal. And I think it's very possible that when this application was made, city planning had not made the decision yet. So there was no way we could have added it to the appeal.
Yeah, I think they're, I'd say those are two separate issues, though. They need to be dealt with separately. And perhaps the order of them should be whether or not it's an arbitrary, capricious, unreasonable test first. And if it makes it past that hurdle, then you go in for the variance itself.
I kind of agree with that. So
I would agree with that as well.
So I think we need to republish it and have the language reflect that. And start an order of what review of the process itself.
Well, my question is, Madam Chairperson, and to the board, the appellant has been before local design and review, before city planning, now before the Board of Zoning Appeals. I would hope that somebody within the BOZA, whoever, would work with them. So, you know, they're trying to follow a process, which I don't think has been made very clear to them what that process is. I was at the Board of City Planning. I was at that hearing, and they were told to go to appeal to BOZA, and that's what they've done. So I think they need the appellant needs some guidance as well as to what they should be exactly applying for. so that, so we don't have to go through this again. I mean,
I agree with that, Councilman.
there is no opposition from the neighbors, as you can see. There is none. There's no opposition from the councilman, myself. I understand, and I understand the process. I've been through it over the years. But if they're going to apply for a variance, then by all means, someone needs to assist them so they apply for the correct variance.
And Madam Chair, to that, the notice of nonconformance that was given to us did not indicate that the design review process was needed, that a city planning commission approval regarding the design review was needed. We just have that code section 350.14H, which states that the board can grant a variance if the proposed sign will not adversely impact the character of nearby properties. B, the design and placement of the sign has been approved by the City Planning Commission in accordance with the general design guidelines established for use by each commission. And C, each display of information shall remain static for a minimum of 20 seconds. Animated or other copy that gives the appearance of motion, unless the City Planning or Landmarks Commission, as applicable, determines that the animated or more frequently changing displays can be accommodated in that particular location. So the City Planning Commission approval is mentioned in that 350.14H on the notice of nonconformance, but there was nothing about the design review. So again, it would be my understanding that this would be a separate application regarding the the City Planning Commission denial. Unless Lori Wagner believes, Attorney Wagner believes that we can just tag that on to the appeal. It's confusing to me as well.
This is very confusing on what the process, because it wasn't written up as an appeal. So this is where I'm having the confusion of, it's written up as if this is just coming to us for, variance approval. But then we hear in the presentation of the case that the signs were already approved by two separate bodies before coming here. And so if the appellant is looking to overturn those decisions, or are we just looking at variances for the case? So that's where we are here. So Ms. Wagner, I believe Ms. Kugler had a question for you. So
Yeah, I guess at this point, the preferable thing to do for the record would be to re-advertise this and continue the case for a couple weeks, and so the issues are clear in front of the board.
I'd agree.
I think I agree with that as well. So Ms. Kukla, how quick can we get them back on the calendar if we advertise this properly?
So today is the 11th. We are doing the agenda for August 2nd this week. So that would be the soonest that we can get them back on.
Okay. McPhillips family, you understand what we're doing here?
So you're saying we submitted the application as variance, but it needs to be submitted as an appeal of variances. Is that correct?
Appeal is decisions, yeah, as previous decisions that were disapproved.
Okay.
So, Madam Chair, to the sorry. So, Madam Chair, to that note, we'll have Mr. Riccardi update the notice of nonconformance. We'll have Mr. Riccardi update the notice of nonconformance, and perhaps we can have the appellant also write a brief statement explaining why he believes that the City Planning Commission did something illegal, arbitrary, or capricious, or not based upon the preponderance of probative evidence. That would be the new standard that Ms. Wagner would add to the legal standard that will be read on August 2nd.
Okay, sounds okay to me. Without objection, board?
Without objection.
Just finally, I can add the section saying that city planning approval is required, but it really is an approval from the City Planning Commission's decision. and not from Building and Housing's decision, which is just pointing it out. So just for clarity, the applicant should be prepared to appeal the decision of the City Planning Commission. Today was obviously a preparation to appeal the decision of Building and Housing in the zoning code. Now they should be prepared to appeal whatever city planning, how they feel city planning was arbitrary or capricious. Just so that's clear. And the appeal can be made directly from City Planning Commission. It's just not. But I think everyone is clear now. Thank you.
Hey, Ms. Kukla, can you make sure that the appellant has what they need so that they can submit properly for August 2nd?
Yes, I think to Ms. Wagner, I think I would just send them the new legal standard, and then they can write up an appeal statement from that. And one more thing to Attorney Wagner. If this were to be appealed to the Court of Common Pleas, do we want them to be separate cases? You're muted, Lori, if you're speaking.
I don't know why you would. You can combine an appeal. Essentially, you're doing two appeals here. One is the appeal of the Planning Commission, well, three, if you want to put it that way. The Planning Commission and design review decisions, but then there's also requests for variances. But I don't know why you'd want to separate that out into different cases. It should all be heard at once.
Okay, thanks.
All right, good. So we have a course of action. McPhillips family, we'll see you back here on August 2nd, and make sure you check with Ms. Kukla about exactly how you submit your application, and we should be good to go there.
Thank you. Yeah, it does.
Thank you.
Email for Ms. Kukla.
Oh, I could send it to you. Do we have your email in our? I could send it to whoever's email that we have in the file.
Yeah, mine should be in file. So.
Okay, I'll send that today.
All right, thank you.
Great, thank you, everyone. Ms. Faith, we're gonna move on to the first case on Lorraine Ave.
All right. Moving back to the first case, calendar number 21-091 at 4157 Lorraine Avenue. Vasily Papouras, owner, and PM Foundations Inc. Platform Beer Company, also known as, proposed to change the use to bar with outdoor seating area and placement of 4 structures for additional seating in a C2 local retail business district and a pedestrian overlay district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record.
Thank you very much, Mr. Donovan.
Will everyone for this case raise your right hand if you're going to testify? I'm going to read a statement. I'm looking for a response of I do with your name. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do.
I do. Steve Jennings.
Anyone else?
I do, Donald Pettit.
Thank you, Don. Anyone else? Last call. Hearing none, on to history.
To Mr. Donovan, through the chair, I only heard 2. I heard a third voice, but I did not hear that person's name.
Okay, could those folks give us the roll call again? Your names, please.
This is Matt Orheck with LDA Architects. We also have Steve Jennings with LDA Architects, and then I believe Don Pettit was the third.
So do you have a letter saying you can represent the owner?
We submitted a letter last week signed by the owner, Vasiliki Papouras, that was submitted to us by him. We do not have the notarized letter due to some timing and travel requirements that prevented us from getting the notarized letter, but we have a signed letter from the owner.
Thank you. History.
Thank you, Mr. Donovan. The property was originally zoned general retail in 1929. In 2012, it was changed to local retail business and placed in a pedestrian retail overlay. I only found in the Records Administration Office that in 1946, a permit was issued to install one 1,000-gallon fuel storage tank. The owner of the property at that time was noted as Standard Oil Company. There are no variances on file. And then in the more recent history, I found that a violation notice was issued on the property for 2013, stating that there was illegal storage on the property of, quote, combustibles. And then in July of 2020, a violation was issued to the property stating that there was illegal occupancy. And that's all that I have, Madam Chair.
Thank you, Ms. Kukla. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting an area variance from the off-street parking requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other landed buildings in the same district, or deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Thank you, Ms. Wagner. Maurice, can we get a summary, please?
Sure. So basically on this one, we're just looking at a parking variance. They are required to provide 44 parking spaces, and they are supplying none. And Mr. Pettit is here to talk about the Landmarks Commission, the fact that that was already approved in the Landmarks Commission. So it's really just about parking.
Great. Well, since you said it, Mr. Pettit, can you go ahead and speak, please?
Thank you, Madam Chair. Don Pettit, Secretary of the Cleveland Landmarks Commission. The commission reviewed this on March 11th of this year. We approved a certificate of appropriateness to install shipping containers, an outdoor patio, site amenities, and it was based on a revised plan which eliminated the curb cut on Lorraine Avenue per the PRO standards, moving one of the containers 10 feet to the east, and the addition of more seating and landscaping along West 42nd Street. We support the project and we have no objection to the required variances.
Great, thank you. So who's here to speak on behalf of the appellant?
Good morning. This is Matt Orehek with LDA Architects.
Hey, go ahead. Present your case.
Great. So, as Don said, we've been to local design review as well as Cleveland Landmarks Commission and received approval from both entities. Per the requirements of the PRO, we eliminated several curb cuts, one along Lorraine Avenue, and then one you can see in the upper right corner that is along, I believe that's West 47th Street. So essentially, with the elimination of those curb cuts, we took away all available potential parking along that Lorraine Avenue frontage, leaving us just a little bit of land in the rear of the property and on the side of the property. We have, and I don't know if you received it or not, but we do have, or the owner does have an agreement with a local business to provide a substantial number of parking spaces to the north of this property. And so a map is detailed in the documents that we submitted last week to BZA. But the project proposes the reuse of the existing garage to a more conducive use for the pedestrian retail overlay in that portion of the neighborhood. We're proposing reusing the existing structure for beer garden. That inside would be the tap house and some limited seating along with restrooms and a small souvenir retail type stop that's accessory to the brewery, along with outdoor picnic tables on all sides of the property. It also involves the installation of several shipping containers that will be reused as sort of cabana style seating that has doors that open up and various amenities inside, including lighting, TVs, that sort of thing. And then we also, at the request of the local design review, position one of the containers along West 47th Street and cut openings on both sides to provide a better frontage along the side street there. And so we're requesting a parking variance with the understanding that we also have a legal arrangement with a nearby business to accommodate for those spaces that are not on site.
How many parking spaces does that bring?
I believe there's over 60 on the additional site, and we only need 44 per our non-conformance letter.
All right. And you have like a 5-year lease to guarantee that, or?
I can tell you, hang on. It's a multi-year lease, yes. It runs through 2023 at this time.
Okay.
Are you able to supply a copy of that to Mrs. Kukla?
We have, I believe she should have that. If not, I can supply it.
Okay. Madam
We
Chair,
we do have that. There aren't dates that are, it does state 2018 as the commencement date. I'm not sure if the board would want to see an updated version of that, but it does say that the end date is July 15th, 2023. I don't see specific number of spaces that are going to be allowed.
So I believe our understanding is that the owner receives usage of the entire site and the entire parking lot that is at what's currently the May Dugan Center. So that the 60-ish was just a count from us. So our understanding is that can receive the entire usage of the parking lot as per the agreement.
so I think we would want to have an updated letter with the number of spaces specifically and the dates updated as well.
Thank you. Anyone else on the board have questions?
I did have another question,
Sure.
Madam Chair. This is looking rather similar to a restaurant facility that's in Lakewood that's extremely popular. And they bring food trucks for food service. Is that something that's going to be happening at this location?
At this time, that's not anticipated. The owner has a property that's just a couple doors down, which is their main location. And they don't use food trucks for that, and certainly that has not been communicated to us that that's the goal. In addition, the curb cut has been eliminated along Lorraine, so it would be a little more difficult to pull in and out of the site as it is. But I think you're probably referencing the Lakewood Truck Park, and at this time, there's no intention of it being the Lakewood Truck Park.
Okay, great, thank you.
Yeah, I think this mirrors more what's happening in Hingetown. We approved one like that before, so I think this is going to look more like over there, Saucy.
The Vibe Garden.
Yes.
Yeah.
Than more of the Lakewood one. Thank you. Board, any more questions? Okay.
No.
City planning. I know we heard from. No, go ahead. We heard from Don. We need to hear from city planning.
Yes, of course, we concur with Don Pettit, and as the applicant has stated, they are providing off-site parking. We also feel that, there's going to be a lot of local people coming to this location that will probably be using alternate modes of transportation that don't involve a vehicle. So I think this is, and there's been no objections from the local committee about not having enough, supply of parking in the area, so we fully support this project.
Thank you, Maurice. If the board has no more questions, I'll entertain a motion.
Madam Chair, I think given the testimony we've heard today on case number 21091, the support of city planning, the support of the Landmarks Commission, that we this looks like a project that is well thought out, and we can go ahead and approve this variance request.
Madam Chair, I'll second it with a friendly amendment that acknowledges the parking arrangement for cars at the May Dugan Center.
Thank you, Mr. Donovan. Okay, call the roll, Liz.
Thank you. Ms. Barnes,
Yes.
Mr. Donovan,
Yep.
Ms. Faith,
Yes.
Ms. Britt.
Yes.
Calendar 21-92 is granted conditionally. It'll be held pending that updated parking lease. And once we receive that, we will ratify it and we will send you a letter.
Thank you.
All right, thanks everyone. Ms. Faith, we're gonna move on to West 32nd Street.
All right, great. Calendar number 21-092 at 3332 West 32nd Street. 3332 West 32nd Street, LLC owner proposes to establish use as a bar with a 15-space accessory parking lot in a general retail business district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record.
Well, everyone for
very
this
much.
case? Everyone for this case that's going to testify, please raise your right hand. I'm going to read a statement. Afterwards, I'm going to ask for a response of I do with your name. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Matt Orhack.
I do, Steve Jenks.
Anyone else? Last call. Hearing none, we go to history.
Thank you, Mr. Chair. Sorry, this is getting me every time. Thank you, Mr. Donovan. There's been no change in the zoning since 1929. In the records room, we found a permit was issued in 1955 to correct violation and use premises for 3 families. In 1958, a permit was issued to correct violations to 2 stores and suites. There were no variances on file. And then in the more recent history in our Acela system, we found that in 2007, there was a vacant lot cleanup, a payment assessed to the property. And that's all that I have.
Thank you, Ms. Kukla. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the landscaping and off-street parking requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and the granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you, Ms. Wagner. Maurice, the summary, please.
Right. So the summary for this one is basically about frontage strips and parking in the setback. There is a little bit of a complication with this project in that, let me bring up a different plan.
Is this complication day here at BZA?
It's not really maybe that's a little bit strong of a word. So basically what happened here is the property adjacent to this one, to the left of the image that you're looking at here, was acquired by the company to put in the parking lot, and it's a land bank lot that they purchased from the city of Cleveland. So originally the land bank lot, which is over here on the left, was supposed to be where the parking lot is. And that's why it was sold to the developer to develop as a parking lot. And then this lot here was apparently going to be a playground or community volleyball courts or some kind of recreational, where you could have some kind of recreational activity. However, that has changed, obviously, and now they're putting the parking lot on the corner, and the sand volleyball courts are over on the land bank property. So I guess Matt Moss, the planner for the area, asked me to find out. Let me get into a little more detail. One of the reasons that the property was sold for parking was that it was an understanding that it would be also available as community parking for the area. And so just asking the applicants if that would still be the case. And I didn't notice any bicycle parking specified on the site plan either.
Sure. So to address the comment about the community parking, at this time we're not aware of that, but we the site most recent site plans do not have the lot gated at all. So if that was something that was a stipulation, certainly we're not restricting that at all. We're just not aware of that. And then because from our standpoint, we're not developing a parking lot as a standalone parking lot. This is accessory to the structure, which will be the grab and go beer. So our intention with this application was not to develop just a standalone parking lot at this time. And then the bike racks, I don't see why we couldn't accommodate bike racks somewhere on the site if that was a requirement. And then as just another point of clarification too, it should also be noted that the owner has purchased the single family home that is 2 parcels away to the south as well. So that would be next to what is currently and in the future proposed as the sand volleyball court, along with an adjacent land bank parcel to the west that they're currently working with the Ohio Department of Natural Resources to build a butterfly garden on what is currently a vacant land banks lot.
Okay, thank you. Well, we're here for the 2 lots that Maurice spoke about, correct? Okay.
Yes, correct. So it's actually just the one parcel that on this page is the farthest at the bottom, which would be the northernmost parcel. And then so the other 2 parcels that are to the upper portion or to the south, we are not here to discuss those at this time.
Okay. All right. So go ahead and present, stick to the variances that you're asking for today.
Great. So as we discussed, we're proposing the rehabilitation of what was, I think, formerly a boxing gym into a grab and go style beer hall with some limited seating on the inside. And then the rehabilitation of what is an existing parking lot, just to clean that up, still using and maintaining the same curb cuts that are along Sackett Avenue and West 32nd Street, additional site improvements, and that's kind of it at this time. We do plan to come back at a later date for the 2 parcels and the usages associated with those, but at this time we're just discussing the lot that the building is on and that the current parking lot is on. And so our goal is to reuse as much of the existing parking lot as possible, putting in approximately 15 spaces, with one-way access from Sackett and then exiting onto West 32nd Street.
Okay, so the variances here are talking about the landscaping strip. Do you have plans for that?
So that is in our understanding is referencing the lot line that is running east-west. So on this portion, it would be just under the clouded section, sort of in the middle of the page here. And so we would long term there would be substantial landscaping between the parking lot and in the future what will be more active uses such as volleyball, outdoor seating, that sort of thing. So at this time we would plant some limited plants there, but we would like to not meet the 10-foot strip. We're providing 6 at this time, just keeping with the existing parking lot dimensions.
Thank you. Board, any questions?
Is there any fencing along there as well?
Not at this time. The long-term plan would be to provide fencing around all 3 parcels. Steve, you might be able to speak to that more, but that's the long-term plan.
Right, just basically following the sidewalk.
Is this a lot consolidation, by the way?
Not at this time.
All right.
Ms. Kukla, have we heard anything from the community?
I have not received any letters other than that support letter from Matt Moss.
Okay.
Madam Chair, the only thing,
Madam Chair, to Ms. Kukla, have we had anything from the councilwoman?
No, not anything.
Okay.
All right, thank you. So Liz, do you want to just read part of what Matt has to say, or if Maurice wants to summarize it, just so we can get the city planning perspective?
I'm sorry, what did you want me
I
to do?
would defer to. Did Maurice give his recommendation? I guess that's the question. I do have
No, he
that
just-
letter
Yeah,
from.
well, yeah, I had asked the questions, which they pretty much answered. I guess the only thing that I would request at this point is, and I don't see it, I'm not saying that it hasn't been submitted, but I have nothing on the landscaping plan for those areas. And again, it might just be that it's not in this presentation, but we would need to see that, I think, before the board would ratify this decision.
But we would accept a 6-foot wide landscaping strip rather than 10.
And we would support that too. We would
Madam
also
Chair,
support the variance for parking in the setback.
Great, that was going to be my next question. Okay, so go ahead, Ms. Kukla.
Madam Chair, the letter from Matt Moss does say that the corner must be landscaped and the lot should still be available as district parking option as the area continues to develop. So
Right.
The planner wanted to see those conditions in the resolution.
Great, thank you. If there are no other questions from the board, I'll entertain the motion.
Madam Chair, could we get agreement from the appellant that the lot would be used for community parking?
Yes.
Did we lose him?
Yeah, if they're trying to speak, we can't hear them.
Yes, we would approve that.
And
Okay.
are you also in agreement to the 6-foot landscaping strip?
Yes, absolutely. We will provide a landscaping plan for that area. I think one area that's of concern maybe would be the amount of landscaping required, given that the plan is to expand to future plan those other 2 parcels. So our goal would not be to separate this parcel from the future with too extensive of landscaping. So that's just one comment. And then to the comment about the landscaping at the corner of Sackett and 32nd, that's we can absolutely do that. That's not a problem.
All right, thank you. Does that satisfy for planning?
Yeah, you know what? I just had one question to ask. Hold on a minute. Let me get the picture up. I'm just curious, what is this white box that's sitting adjacent to this, what I believe is a portable restroom facility?
Steve, do you know? I have no idea.
Yeah, I assume that you're talking about the one that's on the ground that the.
Yeah, on the bottom
correct.
right photograph. Is that the septic tank?
Yeah, I believe so.
Okay.
And
Way to bring
obviously,
way to bring us down,
I
Maurice.
assume
Thanks a lot.
I assume that's going away.
well, yeah, part of the improvements is to provide the restrooms in the building so that this can go away.
Okay. When I took the pictures, I thought that's what that was, but I just wanted to be sure. Okay, thanks.
Okay. There's no other questions. I will entertain a motion for it.
So, Madam Chair, with regard to calendar number 21-092, I am so sorry, my voice is going. With the provision that the appellant's representatives provide us with a landscaping plan and I'm sorry, what was the other requirement that we wanted, Ms. Kukla?
Public parking.
Public parking, yes. The statement with regard to the parking being available for the public.
And a bike rack.
And a bike rack, yes, absolutely a bike rack. I move that we go ahead and approve the variances for this case.
Second.
All right, call the roll, Ms. Kukla.
Ms. Barnes?
Ms. Barnes,
Mr. Donovan?
Yes.
Ms. Babe?
Yes.
Ms. Britt?
Yes.
Calendar 21-92 is granted conditionally pending that updated that updating site plan showing landscaping and a bike rack, and also a statement that you've agreed to shared parking with the community.
Great. And just a question, we can submit that when we submit for permit? Or when do
No,
we
we would
submit
need
the
that.
updated plan to you?
Yeah, we would need that before ratification. Is that
Okay,
correct,
got it.
Madam Chair?
Sounds good. Thank you.
Thank you.
Bye-bye.
Thank you.
Thanks. Last case.
All right, here we go. Wrapping up today, I'm sorry. Calendar number 21-096 at 1625 Rockwell Avenue. HS Data Solutions owner proposes to display a 5,120 square foot billboard / wall mural in a semi-industry. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record. And it sounds like it's a good thing I'm reading our last case.
Yeah, get yourself some hot tea, Miss B.
Everyone,
Okay.
With honey.
is everyone for
It's
this
been a
case?
very interesting morning for us, so thank you.
Can you raise your right hand? I'm going to read a statement. The response is I do with your name. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth?
I do, Anthony LaGuardia.
I do, Jenna Baker.
Anyone else? Last call. Hearing none, on to history.
Thank you, Mr. Donovan. There's been no change in the zoning since 1929. I did not find any records in our records administration office. I did find that there is one variance on file, and it is on the screen before you. In 2017, this board granted a variance for a 1-year wall mural / sign at this location. I believe it was the exact dimensions. It was it was in conjunction with a 1-year contract with the Cleveland Indians, allowing them to use their logo. And that is what I have that is relevant.
Okay, we'll go to the legal standard. Then I have a question after that.
Thank you, Madam Chair. Members of the board, appellant is requesting use variance and/or area variances from the sign regulations of the zoning code. And I did say and/or because it's not clear to me whether Building and Housing has determined if this is a billboard or a mural. If it is a billboard, then that will require a use variance, and I will read the standard in just a minute. If it's a mural, then that's just an area variance from the requirement of 6 murals maximum in the central business district. So the legal standards to obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you, Ms. Wagner. Maurice?
Yeah, I was just looking for my code book and it apparently fell down. So hold on a second. Let me get back to there. Yeah, so this is pretty basic again. 2 basic issues: determining really whether it's a billboard or a mural, the way I see it, and then if it's a mural, just are we going to allow them to have the mural based on the fact that there's already 6, which is the requirement for the downtown area.
Thank you. Could you go back to what we granted in 17? So my question is, the square footage seems to be a little less for this than what we granted in 17. Ms. Kukla, what necessarily is the difference between Because I remember this case. So what's the kind of difference between what they're asking for today and what we granted previously?
Well, and Madam Chair, you can see now in the aerial that I have up there, this is an older aerial, so it does have the old Indian sign that was up there.
Yeah, I mean, I pass it at work every day, so I know exactly like where this is.
And this is the new sign that they're proposing, which from city planning's perspective, we would consider this to be a mural. There's very little advertisement on this sign other than the mention of the Rock and Roll Hall of Fame in the upper right-hand corner.
Right.
And considering that there was probably more direct advertisement for the Indians than there really is here for the Rock and Roll Hall of Fame. So we really feel that this is a wall mural. And we would support the addition of, I guess, what would be a 7th wall mural downtown, being that there are already 6 existing.
Thank you, Mr. Rulins. I tend to agree.
Sorry if I spoke out of order.
Oh, no, it's fine. No, it's totally fine. We were kind of in that conversation anyway, so that's fine. So I will hand it over to the appellant now. So even though Maurice kind of, did your case already for you, but go ahead and present.
You did a great job for us. We appreciate it. No, we just, again, we view this as a wall mural. It was approved in 2017 to beautify the area here on the wall. It was a community partnership between the Indians and H5 Data Solutions at that time. And now we're just looking at another 2 important companies, H5 and the Rock and Roll Hall of Fame, just looking at a way to beautify the wall, beautify the area with a wall mural.
I just have one question. Is this a piece of material that's stretched and attached to the wall? It's not actually painted to the wall, correct?
No, it's a mesh material that is stretched through a system that was welded onto the wall.
And I would also add that they definitely meet the requirement of what I would consider to be an unsightly wall.
Yeah, I was always, yes, I was always felt better when I passed it going to work to see something there versus this. So I agree with you totally. Board, do we have any questions?
The only question I have is, and it's never come up before, but in a way, are we legislating this particular expansion of a zoning issue? In other words, they said you can only have 6, and we're saying no, we're going to let you have 7. And I mean, in terms of process for other people that want to put art murals up in downtown or wherever, how does this affect that particular situation, if it does at all?
Legally, the board does have the authority to grant the variance. We have considered that as an area variance because wall murals are allowed in the district. It's just the maximum number. So I think it would be similar to a variance to allow a group home within 1,000 feet of another one. That would be the standard. And so it's up to the board as to whether they choose to grant it. And if other applications come in for wall murals, the board would have to examine each of those individually.
As I recall, the last case that we approved with the Indians thing, there were other people in line trying to get their murals up, but that one kind of cut in line, I guess, for lack of a better term, through our variance. Who's in charge of that program, Maurice, do you know?
I do not know. And I will point out that Mr. Riccardi has his hand raised.
All righty, Rudy. Mr. Riccardi, what say you?
No, that was from before.
Oh.
Sorry.
Oh, I'm sorry. Okay. I will point out that the last time you basically did the exact same thing. If you read in the one paragraph.
Yeah.
The director stated that
Yeah, and then we
Commission has no
decide that this
objection.
was, yeah, I'm sorry. Then we decide this was a billboard too as well for the Indians. So that's what made this one a little different because we're not.
That I don't. Liz, do you remember?
Or did we write it up as a mural?
I can't read it.
Director of City Planning Fred Collier was present to express that he had some difficulty defining the sign. He stated that the billboard definition is problematic as billboards are not permitted in the central business district, but murals are permitted with a limit. Stated that commission has no objection to allowing the variance to increase the number of murals permitted downtown as per the appellant's proposal. After some discussion, the attorney for the appellant suggested that the board allow the mural for only 1 year. So it seems as though the Director Collier did determine that it is a mural and not a billboard.
Gotcha.
Does this have a time limit on it as well? I mean, is it like a 1 year deal?
Madam Chair, to the Mr. Donovan's question, that was not part of the application made to our office. So this will be permanent.
That would be to the applicants then.
The applicant, is there a time limit on the relationship here?
No, we would love to, get a permanent one on this one. We don't have anything set in stone where we're looking to change it anytime soon.
Okay.
Madam Chair, I do have a support letter from Councilman McCormick. He states that he's in full support of granting the variances. H5 Data Solutions is not only a valuable business in the city of Cleveland, but they also have experience in displaying quality murals on their property. Their murals add to the vibrancy and quality of life of the downtown Cleveland.
Thank you. Any other questions, board?
Nope.
If not, I entertain a motion.
Madam Chair, I think given the testimony that we've heard, the statement read by Ms. Kukla from the previous case adds weight to the decision here, and that we deemed that this is a mural, that we go ahead and approve this variance.
Second.
Okay, call the roll.
Ms. Barnes? Ms.
Yes.
Thank you. Mr. Donovan?
Yep.
Ms. Faith?
Yes.
Ms. Britt?
Yes.
Calendar 21-96 is granted. It'll be ratified next week and we will send you a letter.
Beautiful. Thank you very much.
Thank you.
Thank you.
Bye-bye.
All righty, on the old business, 1 through 3 without objection.
Without objection.
All right, we have affirmations for Churchill Ave, CMHA, and then, oh, that's a restatement. Okay, we'll do the affirmation first. Without objection on affirmation?
Without objection on that.
Without objection.
Without objection.
Okay, and we have a reinstatement for West 57th Street for the grass cutting. I remember he wasn't there, so he didn't have the right date on his calendar. That's what he says.
Yeah, he said there was a schedule, a confusion with the date. We did send him out a letter for the record, but yeah, he made a mistake and is asking for forgiveness.
Okay, what say you, board?
Without objection.
Anyone else?
Well, I think it's unfortunate he didn't have his schedule in order.
You're okay with him coming back then?
I'm fine if he wants to come back, and everyone, we're all okay with it.
All righty.
And Madam Chair, we could give it the date of August 2nd, or we could do August 9th. August 2nd is filling up.
Yeah, let's do tonight. Let's do tonight.
Thank you.
You'll probably have to cut some more. You'll probably have to cut some more grass by then.
Yeah, he will.
Yeah. Yes. And so I was looking at the calendar number, UCI. What's this about? They're taking us to court.
I believe that was that large project that was just approved.
in Little Italy.
Oh, yeah, the neighbor
That was
across
just a
the street.
couple
Yeah,
weeks ago.
yeah. I figured that was happening because he had his attorney there at the hearing, so I figured he was going to take us to court on that. Okay.
Yeah, we kind of knew that was coming.
Yeah.
Okay, could I ask a question about whether or not there's any movement to replace Carol on our rostrum?
We haven't heard anything yet.
We know they're
I-
moving, but we don't know what's happening.
Right. I mean,
Well,
Fred
given
has
the
told
fact
us-
that we're gonna have a new mayor, I'm just wondering, you know, is it gonna get done or are we gonna wait for the new mayor?
I
No,
think the current mayor is going to try and fill all these
Yes.
spots.
Yeah.
Okay.
That's what we've been told. Whether it actually happens or not, I don't know, but that's the intent.
Exactly.
All right.
Okay.
Okay. That's it.
All right,
we're
got
done.
one under your belt, Kelly.
Yeah.
Yay, Kelly.
Thank you. Thank you.
Good job.
Maybe we can ask
Okay,
people to
everybody.
try to check in a little bit earlier, like, you know, a quarter after, so that we don't have the butterflies. Where is people?
Yeah.
Yeah, we were a little bit worried today.
Yeah, because we only have 4
Nice
potential.
job, Kelly.
Thank you. Yeah, because we only have 4, so we get nervous when people don't show up. Okay. All right. We'll see you guys next week.
See you next week.
All right,
Bye-bye.
bye-bye, everyone.
Yeah.
I'm headed for tea.
Yes.
Good.